Thank you, Mr. Chairman, members of the committee. Good to be back in front of you again and debating what has become a very hot topic in our state and one that has drawn a lot of attention from folks both for and against. I get that. And so let me just kind of walk through what we did last year. Last April, we took a big first step with the passage of Haley's Hope Act, and I'm grateful to the members of this committee that helped us perfect that bill, get it workable, a solution that gave some relief for our medical refugees who have gone to another state to seek medical cannabis. It provided protection and prosecution for possession for 8 medical conditions and a maximum of 5% THC with minimum CBD and THC ratios. As of today, there are 517 citizens who have signed up for the registry. 517 citizens who have said, yes, I want this as an option for my medical diagnosis. There have been 212 doctors that have signed up for the registry. So a significant amount of both citizens and physicians who have signed up and wanted to use this as an option for either their patients or for their practice. But we knew when we passed legislation last year that there was still going to be one big, huge barrier. How do you access the product? We allowed protection from prosecution and possession for citizens that were properly registered with the state, but we didn't provide a mechanism of how could they get a safe, lab-tested, effective product here in Georgia. So many of our citizens and those that have been registered with the state have had to resort to a couple of different options. One of those options is there are a couple of reputable manufacturers that are shipping the product to Georgia, a very low THC oil product. It's below 0.3% THC, so it's basically considered hemp. That's still a gray area in law, but many of the families with who have children with seizures have been able to get the very, very low THC oil product. Others have traveled to another state, obtained the product there legally, violated federal law, and risked arrest by bringing it back to Georgia for themselves or for their families. So in effect, while HB 1 and Haley's Hope Act was a huge big step of providing an opportunity to possess cannabis oil here in Georgia, we still ended up making potential criminals out of families, parents, citizens who still want to access medical cannabis oil here in Georgia. We always knew this was only the first step. In fact, in HB 1, when we passed it last year, the governor, included in the bill, was the creation of the Medical Cannabis Commission. Created the governor's request to see what is the best model for potential in-state cultivation. That commission met over the last 9 months and against my recommendation did not support in-state cultivation in the state at this time. It should be noted that of the 5 medical professionals, 5 doctors on this commission, 4 of those doctors voted in favor of an in-state cultivation growth for medical cannabis. 4 of the 5 physicians voted in support of in-state cultivation. Because, in my opinion, I think their stance, and you have to ask MAG and other associations, that they believe that if it is going to be the law of this land to allow possession of medical cannabis in Georgia, doctors want to know what their patients are taking. They want to know that it's safe, that it's been lab tested, they want to know what's in it, and so that's why I believe the medical community, 4 out of 5 physicians on the commission voted in support of that. The commission did suggest that also that the Minnesota model contained best practices for a potential in-state cultivation model here in Georgia. If I can real quick, and we'll hit a couple of the high points. It's a limited licensee program. There will be a minimum of 2, maximum of 6 licenses granted to individuals who have the ability, both financial ability, the moral capability, the background and experience to be able to set up a vertically integrated model. Meaning these licensees that are granted to folks here in Georgia would be, they would grow it, the product, they would process the product, and they would distribute the product all here in Georgia. Vertically integrated models, 2 to 6 licensees. There would be a seed-to-sale tracking system, and meaning every plant would be tracked for security purposes from the moment it's in the ground to the moment it was given to the individual. So seed-to-sale tracking system. There'd be limited medical conditions. As we know, we have 8 medical conditions now. We are looking at adding 9 more medical conditions, including autism, Tourette's syndrome, Alzheimer's, and PTSD, as well as intractable pain. We've created a new definition for intractable pain that is stricter and more stringent than what is in the current code for chronic pain to make sure that there would be potential abuses from it. There would be, smoking would be prohibited. Smoking marijuana would be prohibited under this law. The only application would be by liquid, pill, or oil. It would be administered by the Department of Public Health. There would be no taxes charged on the purchases. It would be treated just like any medicine. When you go right now to CVS or Walgreens, you're not paying any sales tax. You're not paying any tax on that product. The same would be here. This is medicine provided for our citizens. A patient would have to be certified by their physician, just like it is under the current law. All product would have to be lab tested by an independent third party, and only licensed pharmacists at the dispensary would be allowed to sign off on giving product to a citizen. Every citizen who would be properly registered with the state would have to have a consultation with a pharmacist at the dispensary before to make sure that it was all understood what would be the interaction with other drugs that might be taken as well. Well, what you're going to hear over the next couple of days in the hearings here are 2 real concerns. One, is there enough demand? Why aren't physicians clamoring for this, speaking for it? Well, without even having an access for our citizens, we have 517 patients who've signed up, 212 physicians as well too. Adding the additional conditions assures that there will continue to be demand for this product. We added the additional conditions because the question that begs to be asked is, if we are going to go down this road of providing medical cannabis to our citizens in a tight, secure, regulatory manner, why would we not want as many hurting citizens who have debilitating illnesses to benefit from that? Why wouldn't we do that? And so that's the purpose of adding the additional conditions. You're also going to hear a concern from law enforcement that this is a slippery slope of moving down toward a path of recreational use. I've been very public that is not a direction I want us to go. I'll fight that of allowing a law for recreational use here in Georgia. And I believe that by having the limited number of licensees, that addresses the concern that law enforcement have that they won't be able to control it. They'll have a maximum of 6 places in the entire state that have to go check. Anybody else growing marijuana in the state is going to be arrested. But those 6 places, the only 6 places in the state, and maybe just 2, that would be the only folks who could do it. The final thought, and then I'll kind of turn over for questions you want, or turn over to folks that maybe we really ought to hear from today. If whether we pass this bill or not, people are going to continue to smoke marijuana to get high. In fact, if I wanted to right now, I could walk probably right across the street and pay $20 and probably get a couple of joints and get high. So whether we pass this bill or not, that's going to continue. To those that say that all of a sudden we're going to, because we're taking the THC limit off or expanding the list of conditions, we're all of a sudden going to have a bunch of people that are getting high all the time. And my challenge to you is this. I'm not sure that somebody that wants to get high off of smoking a joint is going to go to their doctor, ask them to certify them as having a qualifying medical condition, have that doctor have to go through the registry process, sign them up, then make a visit to the dispensary and have a consultation with a pharmacist, and then pay $250 for access for a month's worth of medical cannabis. I don't think that's going to happen for somebody who wants to get high. They're going to go down the street, buy it for $20, and get their psychoactive effect. So why wouldn't we set up a regulatory structure for citizens that legitimately have incredibly debilitating illnesses, some of them you're going to hear from today, who all they want is a legal access to a safe, lab-tested product here in Georgia. Why wouldn't we do that for our citizens? And so that's the case that I'm going to try and make before you over the next week or two. And I look forward to working with the committee and perfecting the bill like we did last year and come up with a product that we can all be proud of, that we can send over to the Senate and let them debate. Mr. Chairman, I'll stand for questions, or I'll let folks get to who they really want to hear from.
Vickers, I'm sorry.
Representative Peake, I would like to thank you for bringing this bill forward to us. I would like to ask a question. Who will pay and run the tracking system? Is that part of the facility? Is that within the facility?
That's correct. It would be required by the licensee to adopt whatever seed-to-sale tracking system the state mandates. That's correct.
Okay, thank you.
Representative Setzler.
Thank you, Mr. Chairman. I know we'll have plenty of opportunity to discuss this in merits and details. And what was the discussion last year? You know, when we opened up the discussion 2 years ago about Kavanaugh and Charlotte's Web and young children that were legitimately and very tragically suffering with seizures. The exhortation and the encouragement was low THC cannabis is something that this is a need, and let's do this. This is a moral imperative for us. And I think over 2 years of discussion and educating people, I think the General Assembly got comfortable with that, and there was a very strong assurances that this is what we need. There's certainly, I think you recognize there were a number of people that had broader intentions across the space, really from A to Z, all manner of ambitions with respect to cannabis, marijuana in Georgia. How does this comport with the assurances from last year that this is what we need, let's just do this?
Well, I think last year was a collaboration of negotiation between folks who still had some concerns about THC level, about conditions that ought to be included. But my intention has always been, how do we help as many citizens as possible? Started with a young little 4-year-old girl named Haley Cox who suffered from seizures. But what we found out is that there are a lot of hurting Georgians that could potentially benefit from medical cannabis, and from an elevated level of THC as well too. You're going to hear those stories today. One grandmother you're going to hear from today whose son only responded to a higher level of THC. A 4-year-old grandson only responded to a higher level of THC. They're still out in Colorado. Couldn't come home. And so, for me, it came down to why not let parents, in consultation with their doctors, and after further consultation with a pharmacist, make the decision of what's the proper dosage of medicine, what ought to be the ratio of CBD to THC, and take us out of the equation, quite frankly. I mean, I'm not a doctor. I don't think any of us are here are. But let doctors make that decision with the patient of what proper level and what the proper dosage should be.
Mr. Chairman, I could just brief if I could. You know, I know we're talking about the substitute that's forthcoming, and it's going to be different than this. Hey, let's not focus on the bill 722 as introduced. But the substitute's going to be demonstrably different.
Not demonstrably, no, sure.
But the bill's going to be different. But I mean, it isn't 722 an expression of public policy? Certainly an expression of intent. Hey, here's where we want. Even if we have to do less now, you know, we've clearly seen a willingness to take incremental steps over time to dramatically, and in this case very significantly, expand what was done in previous years vis-a-vis cannabis. And 722 in its existing form is at a minimum an expression of your and your co-sponsor's intention of where the law would be now. It is a dramatic change from before. the fact that you can get 80 to 90% THC resin, honey oil, or whatever the street name would be, and ingest that in various ways, but not smoked. Take smoking side, but all other ways, and that any physician or any two physicians could prescribe that for someone with pain and chronic pain and so forth. Now's not the time, and I won't belabor the point. We'll have plenty of time in this committee to kind of go forensically through the bill and discuss the implications of each provision. But this is a dramatic departure from where we were last year. I don't know that I'm completely surprised, but I want to say for the record, it is a dramatic departure to allowing the ingestion of pure, THC resin for someone with chronic pain. I think that's, again, I want to, perhaps for members of the audience or the committee that weren't present last year, this is a substantial change from this expectation of, hey, we're going to take care of a very narrow subset of people.
And I would make the argument, Representative Sessler, that we ought to take care of as many people as we possibly can, provide the medicine that can help make their day and their life a little better.
Representative Kendrick.
Thank you, Mr. Chair. My question was about the licenses. You said 2 to 6 would be granted. Is it per year or in total? And then who would be in charge of, how would the decision-making process go with this one?
Good question. It would be a minimum of 2, maximum of 6 at any given time. That decision would be left up to the Commissioner of the Department of Public Health. It would be a criteria that would be laid out for licensure that would involve financial capability to be able to have a vertically integrated system, experience in horticulture or related field, moral character of these folks. There's not a felony conviction in the past, and the ability to be able to sustain a business on a going forward basis. And that's consistent with what's done in many other states. Some states have cultivation at home and allow you at home. Our model is set up with a very strict regulatory structure for just a limited number of licenses.
Representative Atwood.
Thank you, Mr. Chairman, and Representative Peake. Thank you. I presented the bill last year. You beat me over the head enough that I voted for it.
I'm grateful for that. A lot of families that are grateful for it.
Now, it was one of the most courageous pieces of a legislator carrying a law in our city. I do have some questions on this, though, and to follow up on the licensing. I'm a little, and we can talk offline. I'm not going to put you on the spot here because you may not know, on how constitutionally to limit only 6 licenses under restraint of trade, especially under federal law, to if you have a business person who is fully capable of operating a facility, tell them I'm going to let this guy is absolutely identical to what you could bring forward. He can have a business, she can't. Looking at the constitutionality of that, and I don't know the answer to that. I'm asking. The other thing is, if you could address, since marijuana is currently a scheduled drug under federal law, would it not still be a violation since it's 5%, correct? 5%?
There's 5% THC under the
Would that clearly be, and I assume it is, considered tetrahydrocannabinol derivative under Schedule 1 under federal law? How do we deal with that issue?
Okay, 2 questions. I'll answer the licensing, and if I forget the other one, you have to remind me. The licensing, I'm going to defer to the esteemed council over there, but it is consistent with what we do under liquor licensing. We offer a limited number of licenses for liquor license. So there's precedent there. There's precedent also in other states who also have a limited number of licensees. So I think we would have some protection there, but I would defer to Ms. Travis probably on the legal question. And what was the second one?
The federal, schedule being currently a Schedule 1 drug, dealing with it on the federal level.
It will still be a violation of federal law, but there are 23 states that are violating federal law right now. There are 15 states who have low THC oil that are violating federal law now. The Justice Department has been very clear in 2 separate memorandums that they've issued that as long as you stay within certain parameters, as long as the state has certain parameters, that they're going to take a hands-off, gloves-off approach. And so, yeah, is that subject to change? Sure. I mean, I guess if a new president came in, it's subject to change, but they're going to have to deal with 23 states that have medical cannabis legislation, plus 15 others that have low THC. So I think we're on safe grounds there. Also, Congress, the last 2 years, has defunded the DEA from enforcing federal law in states where there is medical cannabis legislation.
Do you know if there's a movement afoot to change it from Schedule 1 to Schedule 2?
I do. There are several pieces of legislation at the federal level to do exactly that. Whether there's support for them or not, we'll see.
Thank you, Mr. Chair.
In my mind, I'm not waiting on the federal government. So. People are hurting and people are dying in the meantime. So.
Okay. Representative Reeves.
Thank you, Mr. Chairman, and Representative Peake. I have a lot of questions and concerns, most of which I think that you and I can probably talk about offline, but for the benefit of the committee here today, I know that in the last week I've heard a lot about the Minnesota model, and that is, I think, how you're looking to model what you're trying to do here after. My question is, from a time frame perspective, where was Minnesota in this process? How many years did they take in getting to where they are now? How many years have they been where they are now? What kind of data do they have, and how many years or how much time have they had to analyze that data to demonstrate the success that you're claiming that they have?
Okay. The timeline, my understanding, is in 2014 session, similar to ours, they passed legislation that went into effect over the next 18 months. On July 1st of this year is when dispensaries were open for business. So it's been open for 6 months right now. Their numbers that they have seen have been similar to ours from a number of patients and number of physicians. I'm hoping to have the Deputy Commissioner of the Department of Public Health from Minnesota, who wrote the law here for our, not Wednesday, but probably the follow-up committee here, so you'll be able to ask a lot of questions of them directly of how their program is going. And so yeah, it's new, sure. There's not a whole lot of data, but all indications have been, it models where I think our state would want to go, that is restricted and very regulated. And so at this point it's been the best model we've been able to point to.
Well, then as a follow-up, what other states are close to what Minnesota's done?
Vermont, I think, has a similar model. New York has a limited number of licensees. I can get that information to you and get it to the committee as what, in fact, we have it readily available. I think, Jacob, don't we? I think we've got a list of all the states.
Is there anybody out there that has done something similar to what Minnesota's done that we've got 5 years or so of data that we can look at?
I don't know that I can answer that question right now, Representative Reeves, but I can sure find out.
Okay.
And we can get that for you for next committee year.
No other questions? Thank you, Mr.
Okay, thank you.
Thank you, Representative.
Members of the committee.